here today to our estate planning seminar, and I'm just going to tell you a little bit about myself, and then I'll tell you about the firm in a bit. But I am a partner here at Warren and Appolon. We are a boutique law firm, and I specialize in estate planning and really love educating my clients. We've been in the estate planning world for quite some time, the real estate world for over 20 years. And, we just enjoy educating our people, our communities, and our clients. And our law firm is an experienced firm. We've been around for, like I said, over 30 years, specializing in real estate, estate planning, and business solutions. And we've been extremely active. And why I say that, it's important, especially when you are planning, right? When you're doing anything, you want to make sure that the firm you choose to handle your legal affairs, your family's legal affairs, your business's legal affairs will be there for you, not only today, but, they're going to be there for you in the future. They're going to be there for you in the future as well. And I can definitely say we are a firm that is established in the future, and will be here. And now that you know a little bit about us, I really want to thank you for coming. And I want to congratulate you. Because when you think about it, there are a couple things that are sure, and one of them is paying your taxes, and one of them is death, unfortunately. So I want to let you know that I'm glad that you're here, and I congratulate you for being here. And just backing up for a little bit about our firm, although we are a law firm, we are not your law firm. This is educational purposes. The seminar is for educational purposes. It does not mean we have a relationship or an engagement, but you are free to do so. After the seminar, I'll tell you how to get in touch with us if you want to move forward. But again, congratulations for being here, because you know what? You're here because you want to learn, and you're here because you don't do the main thing that stops people from planning. And it's a word that we hear all the time. And we find that it's the number one reason that people either don't have an estate plan at all, or they may have one, it's old, it's obsolete, they set it and forget it and don't even think about it. But that word is procrastination. A lot of us really procrastinate. Um, and let's face it, on a daily basis, it's more important to figure out what we're going to have for breakfast, lunch, dinner plans, date plans, what we're going to watch on TV. The Olympics were just on, right? That was more fun to think about. Everything is more fun to think about than an estate plan. So I'm congratulating you for being here, because hopefully you have the desire, and you're showing the desire to get past that hurdle of procrastination. And there's also another reason why people don't have up-to-date planning or no plan at all. And you're not alone in this, right? It's lack of knowledge. You've heard of different techniques, wills, trusts, different ways of owning title, but it sounds so confusing. You may have an older trust, and you don't know a lot of the advancements and newer planning techniques available. So I get it, but hopefully if I do my job here properly, I'll impart to each and every one of you knowledge and information that will assist you in moving forward and doing proper estate planning, or at the very least, get you thinking of what's important and what's needed, right? And one big thing is really thinking of our family dynamics. That's really where it starts. It starts with that, believe it or not. So being here, we're going to try to educate you so you make the best possible choices for yourself and for your family. I'm also going to share with you the secrets of estate planning. There's so many misconceptions around estate planning. There are mindset issues, there's confusion. So hopefully once you get that real understanding of what estate planning means, and not just the book definition, but what it means to you, right? What documents you need, how to get them in place, you can make an educated and informed decision about what's best for you, your family, and perhaps your business if you had one. All right, so we're going to share some of those myths and misconceptions. And here's one thing I want to share with you with the myth. One huge myth I hear is a lot of clients say, oh my goodness, I don't have any money. I don't have anything. I don't need a plan. That is wrong. A lot of people think estate planning is about money only, but it's not true, right? That's why we like to discuss life and legacy planning, because it's about your life choices, for today, for your children. It's about your assets, no matter how much or how little. It's about the people you love, and it's about control. So yes, you may not have that money to plan, but think about what the cost is. And I'll talk a little bit more about that when you don't plan. That cost could be prohibitive. It's expensive, right? So don't think about it like I don't have enough, right? I don't need to plan because I have no money. You need to plan because you have life and other things to protect, like your person, your health, your children. Also, another myth is spouse thinking that, oh, I'm the spouse, I get everything anyway. And so they married people think they don't need a plan because their spouse does get everything. The truth is that a marriage certificate does not mean your spouse gets to make decisions for you, and your spouse may not necessarily get everything. It depends on the assets you have, how they are owned. Okay, it just depends. I had a woman come in to see me. She realized after her husband's death, she didn't own her house outright. They owned it jointly while he was alive. And she thought she would get everything, but she didn't realize that her two children were also joint owners of the property. She could not sell or move that house without their consent. And the children didn't want to sell. So that lady's now facing foreclosure, right? You have to know how to plan to avoid those situations. The house that you work hard for, you live in. Don't make presumptions. We don't know, right? We don't know. But I'm telling you, as a spouse, it does not mean that you automatically get your assets from your spouse once they pass. And I touched on this last myth. I don't have money to pay an attorney for this. I can't afford to pay for a plan, right? The state's plan for you, and we'll talk about that as well, will cost you and your family way more. You think you can't afford estate planning, but the truth is, if you don't have a plan, your family bears the cost, not just financially, but emotionally. There's left holding the bag, so to speak, and trying to figure things out while grieving and mourning. That is not the plan that you want. Imagine the time, how time consuming it would be, costly it will be. And the state's plan is not always your plan. They may plan to give it to someone that you don't want to get your hard-earned assets, house, etc. And in New York, probating an estate is really expensive. So it costs way more, believe it or not, to have no plan in place than to pay for an estate plan and do it properly and have the control that you want and need in estate planning. That's really what it's about. Another huge inhibitor from planning is our mindset. I know it sounds quirky and corny, but mindset is everything. That's where it starts and ends, right? And I'm not the only one who believes that. This is a quote right from Forbes. Okay, while the most important aspect of your financial life beyond your level of income, like I touched on before, beyond your level of income or financial plan is your mindset. Having a more optimistic mindset doesn't necessarily mean good things will happen overnight. It just means that you'll be more likely to take necessary action to achieve what you want. And that is the truth. Being here today means that's your first step in that action in achieving what you want. Not only about financial, but about control over your assets, control over your legacy. And if you don't believe me, there's celebrities out here who had tons of money, but no plan. They had in common that they had no plan in place. They wanted the state to decide for them. So we could tell you right now, finances were not an issue for Prince and Aretha. What was an issue was having no estate planning documents in place or having the wrong estate documents in place and not properly fulfilling the obligations for those documents, whether it's signing, having several. The court was fighting with the family, and it cost millions of dollars. The state got millions of dollars, especially in the Prince case, right? And Aretha, her fortune was almost $80 million. But because of poor estate planning, the Queen of Soul, her children in 2021 did not see a dime of her inheritance. That was then. It's changed since. But these are just examples that it has nothing to do with money. This is just poor planning, no planning, and could be poor mindset. So let's talk about estate planning. What is estate planning, right? What is it? It's leaving a legacy. It's about life and death, family and community. At the end of the day, estate planning is giving your assets to who you want, when you want, in the manner in which you want to give them or leave them. And when I talk assets, that could be in your bank account, your retirement account, your investments, your real estate. That's what your estate plan is, your legacy, your person. It could be, something that you want to leave in the family, an heirloom that means a lot to you. Your estate plan is very personal to you. All right. So it's not just, this word that we hear, estate planning. It does mean something, but it is all of your assets and what means the most to you. And when you think about estate planning, who are you doing it for? You're doing it for your family, you're doing it for your business, and you're doing it for yourself. And it's not just for you if you have a lot of money in the bank. Okay. It's for you, especially if you ever become incapacitated or disabled. And we saw in 2020 something that rocked our world in a manner that we did not expect. We saw COVID. And COVID, unfortunately, took a lot of people out. It also had people in incapacitated forms, and it left people really frantic because a lot of people realized they had nothing in place. If you become incapacitated and cannot manage your legal or financial affairs, if you can't make healthcare decisions for yourself, someone needs to step forward to handle those things for you. Who would be that person? Who would be the one you select if you could not handle things for yourself? Right? So when you think about it, you have to really know, am I ready? Am I ready for something like COVID to ever happen again? Not to say that it would, but are you ready? And, another interesting fact is that people are living longer, different sciences, medicines. There's so many things out there, but people are living longer and longer. So the chance that you may be incapacitated is greater than the chance of you just dying and being disabled. That's a higher chance, and people are living longer. Start protecting yourselves, right? So get a plan in place. And let's talk about the risk if you don't. We touched on the risk if you don't plan, and if your family doesn't have a plan. Because, like I mentioned, estate planning isn't only about you, it's about the people you're leaving behind. What is the risk to your loved ones if you get sick or pass away without having your wishes in writing? Again, your family's going to be the one left holding the bag, literally. And it could be time consuming, it's expensive, it's draining. And if you don't have a plan of guardianship over your children, the state actually makes that decision too, right? So not just guardianship over your person, but guardianship over your children. The state actually makes one too. And let me tell you a little bit, because people hear these stories, these Britney Spears stories, Wendy Williams. How did they lose access to their estate? How did they not have a plan? I don't know. But I do know that what can happen is the court and the state steps in, and there goes your estate. There goes the hard-earned dollars you worked for. There goes your control, because you no longer have a choice in the decisions you make once that happens. It's very difficult to reverse. Very, very difficult. Again, every state does have their own plan, and it goes in accordance with your state's law. I am, my place of practice is in New York. However, it's very similar. You would have to look into your state to see what the state's laws are. This is, again, overarching information. It's helpful for everyone, but there's some nuances that are different. And so you have to know what your specific state would do with your estate if you didn't have a plan, like a will, a trust, all of that. Okay. And let's look at what a good estate plan looks like. What do you have? Like, what does it mean when you feel like you have a good estate plan? So a good estate plan must include a disability plan. We talked about that. But it must pass your values to the next generation, name a guardian for minor children, protect loved ones from bad decision-making, provide for special needs family members if applicable, minimize taxes, court fees, and unnecessary costs, and take care of you if you get ill. So that's really what a good plan looks like. And these documents that you see in the triangle, those are the documents that you would need for your plan. So a power of attorney, that dictates who would handle your legal and financial matters. You would appoint an agent to do that, an agent you trust. You could also name an agent in that document that if something happened and you could no longer pay bills or you weren't in charge of your financial affairs, that person would step into your place as your guardian or conservator. So you could avoid those conservatorship issues that I mentioned that poor Wendy is going through, that Whitney was in for many, many years. So that power of attorney document is very powerful. And the key is having someone that you know, an agent that you know and trust. Something to note with the power of attorney is that it only is in effect if you're incapacitated, but once you pass away, this document also dies with you, so to speak. Advanced healthcare directives, that's another wonderful document. It helps you to decide who would make medical decisions on your behalf, I'm sorry. What agent would do that? You would dictate that with a healthcare proxy. A living will is a document that includes your end of life decisions. So do you want to be resuscitated? Do you want to be an intubator? What are your wishes? A lot of people and many clients say, oh my gosh, I don't know. But look at your quality of life. I always say, look at your quality of life. Do you want that same quality of life going forward if someone were to resuscitate you? And would you have that same quality of life? So these are things that, again, ironically, not don't really have anything to do with finances, but control over your person and you deciding what you want and letting someone know what your decisions are. A trust and a will also, okay? And we'll talk about a trust and a will. So just as an overview, a trust is a document that's very similar to a will. So a will is a legal document that provides instructions on how to distribute your property. It goes to beneficiaries. Beneficiaries are the people that benefit from your will. The executor now is the person that you would appoint in your will to make sure that your will is adhered to. And that is also the person that would file your will and your documents in court. So yes, with a will, there is something called probate, right? So there is probate involved and there is a court involved with a will, and it can be very expensive. Trusts are legal structures that protect assets, and they do the same thing a will does, but they do it a little better, right? So with a trust, you won't lose 2 to 7% of your estate in probate court. In New York, the average is about 6% is what it costs to probate a will in New York, depending, and that's 6% of your overall assets. So if your overall assets, for example, are $500,000, and we look at the 6%, and I'm saying in New York, 500,000 is pretty low, but I'm lowballing it. You would probably pay a minimum of $30,000 to probate your assets in New York. Not to mention, it takes years for you to probate. It could be up to a year. I don't want to say years. It could be, the average is 9 months to a year to probate. And it's a public document, right? And everything is distributed outright with a will. Everything is distributed outright with a will. So meaning that any children, the minute they're 18, they're considered adults in the eyes of the law. They get everything one time, one shot. So let's start with the living trust. What is that? Because I think most people are familiar with what a will is. They understand that they need a will. They understand that a will is a document that they need for upon death, but do understand that a will is only effective upon death. A will does not take effect until someone passes away. So I know I've been talking about incapacity a lot. I've been talking about disability a lot. Think about that. If a will is only effective once you pass away, if you were incapacitated or something else were to happen, that will would do nothing for you. And a lot of people don't wrap their minds around that thought, but that will would actually do nothing for you. So you need something more airtight. And that's why we start to educate around a living trust. It's very, very similar, but it's superior to a will. And a trust does the same thing. It is a will substitute. That's what a lot of us call it in the legal world, but it's a better substitute. And in many instances, it's a better option. So it creates order out of chaos. And the trust, unlike a will, is not just effective upon someone's death, it is effective for different stages of your life. So right now, it's effective for persons who are healthy and competent. We're talking about a revocable living trust. It's effective for when people are healthy and competent. It has an incapacitation clause that we add in there. So God forbid something happened, it protects that too. And then it protects you when you pass away. So it's there for you for all stages of life. And it's very flexible. During your life, you are the person in charge. You are the creator of the trust, also known as the grantor. You are the manager of the trust, meaning you manage and control what goes in and out of the trust. And you are also the beneficiary of the trust. So you benefit from all the assets that are in the trust. So you have full control. You don't lose any control. So that's a good thing to consider. When you're considering a living trust, it's like your alter ego. A lot of people are afraid. They're thinking, oh my gosh, if I have a trust, I lose all control. And you don't. And in fact, you gain control, and you gain control for all stages of life, which is so important. But when you sign a trust, there's an important second step. So the difference with a will and a trust is that the trust requires a second step that is necessary, okay? Transferring of the asset titles, because when you set your trust up, it is fantastic language. We make sure the language in there protects you, your loved ones, your beneficiaries, you as the owner of the trust. However, if you don't retitle your assets into the name of the trust, and a simple way for retitling is just renaming. So if your house is in Betty Clark's name, you will now have to rename your house, the title, into the Betty Clark Revocable Living Trust for the trust to be in effect. So you will have to make sure that that second step is done. Without that second step, then the trust will do nothing for you. So it's really key and critical. And a lot of times people say, well, I did my trust online, and I don't want to judge anyone for doing that. You do what you think is best, but a lot of times there are little details that these online services will leave out that they don't tell you. So you've created this trust, but when the time comes for your trust to work, it doesn't. So it's really important to know about that second step. And again, we'll go a little bit more into the trust. During your lifetime, who is in control? You are. So you're in control just the same as you are today. You can open and close accounts, make investments, buy and sell, refinance any real estate property you have. No property tax changes, which is a big one. A lot of times when people are a little, they want to preserve their property tax and their property tax benefits, that will not change. Your income tax they're returned and filed the same way as they are today. You can control it, amend. So you'll see the flexibility in this trust. And a lot of people were afraid of trust in the past because they didn't understand that with a revocable living trust, you maintain control. You maintain control. You could tear the whole thing up and start all over again. It doesn't matter. You can do that with your revocable living trust. And why should you get a revocable living trust? There's so many reasons, but the very first reason is that you want it to be distributed properly. You want it to go to the right people at the right time, not necessarily all at once or outright. You want to keep the wrong people out. You want to maintain management. You want that trust, like we've discussed before, for when you're ill, disabled, or incapacitated. And for after you're gone, you want it for the beneficiaries who need your help, who you're leaving this trust for, essentially. So it's so important to know that having a living trust doesn't make you lose control, but you gain total control. You want it for preservation. We touched on that before. Avoiding conservatorship. When you think that, think Wendy Williams, losing control of your finance and your assets, not having access to your bank accounts. It avoids death probate delays. So remember I said a will is something that takes time, expense, it's public. A trust is the opposite. With a trust, there are very few delays. There's a small trust administration done with an attorney, but once your assets are transferred in, remember that second step? Yes, then you will have no probate. You will not have to go to court for your beneficiaries to get access, and it's a private document. So it's not out there in the public for everyone's eyes. Okay, if you're single, it protects you against claims. And if you're married, it could form as a way to reduce or eliminate estate taxes when there's an estate tax issue. Right now, um, I think it's 13 million approximately federally. So if your assets exceed that, then you would have a potential estate tax issue, and that is federally. And for New York State, it's about 6 million approximately. I'm giving you approximate. So in New York State, it would be approximately 6 million. If it exceeds that, then it would say, okay, we would have a problem, maybe potentially with taxes. Let's look at how to avoid that. And so your state may be different. You would have to look into that. Okay, and it's the only estate planning vehicle that achieves all of these objectives. Okay, save time and money, avoids probate. You put all your guardianship wishes there, and it really just gives you full control. So getting a living trust may be a no-brainer decision, not for all, but as I mentioned before, all living trusts are not the same. You want to make sure that it has the right protective language in there. And with that right protective language, you would be totally and completely, and more importantly, your beneficiaries will be protected. All cars are not the same. They're not all the same price. All cars are not built and maintained the same. So you have to think about what is so important in this trust. And I want to make sure that I go to someone who knows to put the right information, to put the right clauses, and what will protect me. So you want to make sure that when you're looking into a trust, no matter who you select, that you are really going about it the right way and making sure you ask the right questions. And the problem with this is sometimes people don't know until they're gone, right? Like the family doesn't know because you don't know that the trust is not effective or maybe things haven't been transferred in. So these are important questions to ask, the second step. And most importantly, who's going to do it? Who's going to do the transferring? Because what could go wrong is that you could think you have a trust that's in effect, and because you have not transferred assets in, and when you don't do that, you may in fact have to go through probate if things are not transferred correctly. So you want to avoid that. You want your will, you want your living trust to properly work when you're sick or disabled. Okay, this is very important. And you want your living trust to make sure, like I discussed before, you avoid conservatorship and probate. These are critical keys of a living trust. One of the most important things a lot of my clients have been asking for is, you know, will my living trust protect my loved ones from losing their inheritance from unwanted third parties or the government? So a lot of times with trusts, they're built in a way that gives beneficiaries gifts that are outright. What does outright mean? It means you get that money right away. There's nothing that stops you from getting that money. If it's a 18-year-old, they get that money right away. If they love to spend money, we know a lot of spendthrifts. We may know of children and that we have in mind that may be spendthrifts. Those are the people that you're looking to actually look out for and protect. So they may not know best, but that's one of the most important things is making sure your beneficiaries are protected, because outright distributions are not always right. Children could be too young, ill, disabled. Someone could be elderly. Someone could have a drug or alcohol problem. Someone is just bad at handling money. Someone could be receiving benefits, right? So if they get distributions outright, it could affect anyone or all of these things. So the key is staged distribution, especially with children. You could say, and you can't do staged distribution with a will. There's only one way, remember, it's to your beneficiary, no matter how old, no matter what's going on, here you go. Right? Staged distribution is a benefit of a trust because it says, I want my child to get their first distribution at 25, then at 30, and if they go to school, they've done everything, they get a bonus or whatever it is, you're in charge of the distribution. And that's a big draw to a lot of people because a lot of times people say, well, I don't have a lot of assets. Well, you may not, but the assets you do have, you want to make sure they're distributed properly in the way you want and they're not squandered. So that's why outright distributions are a no-no. Okay. Another thing is people say, well, my children are great. Everything is perfect, fantastic. So I'm okay with that. But you may still be wrong because if you think to yourself, okay, my child is great. What about if your child gets married? Right? Your child's spouse can take an inheritance in a divorce. Creditors are up for grab. They can just take what they'd like, right? If you have those outright distributions. Government can force it to be spent or paid over to them, depending on if they have that situation. So these are things to think about. Outright distributions are the wrong way to go. So what do? We have something, instead of outright distributions, we have something called personal asset trusts. Beneficiaries can control how the money they receive, but it does offer greater asset protection. And we hear the word asset protection a lot of times, and we may not know what it means, but asset protection is really saying, how can I avoid the wrong people to get their hands on my asset? How do we do that? So asset protection is really important and helpful. And so when we look at asset protection, we look at usually from three children's perspective. We have three children here. We have Bob Jr., Jane, and Jim. Bob Jr., he's got a high maintenance spouse, a risky business, potential for a second estate tax. Jane she looks good, but she lacks financial experience and she's in a problem marriage. And Jim is probably getting government benefits. He has a lot of creditors. He's going into bankruptcy. What would happen in a trust where you did not protect these assets going to your beneficiaries? They would be gone. They would be gone. So you really want to say, not only are you looking at protecting yourself, but you're looking at protecting those assets in the long run and keeping it in the bloodline or keeping it in your line of inheritance, just so they're not squandered or taken. So instead of being gone, your children's assets and inheritance is protected. This personal asset trust is something that we build as an amendment that is added to your living trust. So even, for example, if you're joining today and you're saying, well, I already have a trust, you can always add this to your existing trust as an amendment. Because now with that trust, everyone is protected from spouses, lawsuits, poor financial decisions, and from losing government benefits potentially if there are any special needs issues or government issues there, right? So these are the things that we really have to think about. And that's why it's so important to go to an attorney who knows what they're doing and how to protect not just you, but your children and your long-term assets. You don't want them getting to the right hand. So this is standard equipment in every new living trust that we build, which is fantastic. Another thing I'm going to touch on is special issues for married couples with young children. So when you think about your children, who is going to take care of your children? And if anyone out there has young children, you may think about something for the temporary, but long term, who is going to give your children the same level of care financially, emotionally? Do you have special instructions? Who will manage your children's money? Who will take care of your children if you can't? And who do you not want to take care of your children, right? That's another consideration, because sometimes we think to ourselves, well, I want A, B, and C to take care of my children. I want this one to do it. And don't always think about your parents, because a lot of times people come in and say, well, I want my parent to be a guardian, which is fantastic, but in the long run, parents are aging as well. So you really have to have special considerations and leave special instructions of who you want. And I think more importantly, who you don't want, because we know there are people there that we do not want to raise our children should we not be able to. Okay, so what we do is we name your guardian in a will. We also give you a standalone guardianship document for both temporary and long-term care. We list backups, say what happens if your guardian gets divorced or passes away. So these are all the things that you really think about when you're thinking about protecting your plan, protecting your legacy, protecting your children, especially when they're younger. And God forbid something happened to you. We all pray it doesn't, but in that event, you'll be ready. Okay, and you can even designate a trustee to manage your child's inheritance until they reach a certain age, and you have that staged distribution as we discussed. So this is really a simple way that we can do it. Like I said, we can do a separate standalone guardianship document if that's some way you want to start, but we also put it in your will. And just one more story to touch on that is you do not have a will. If you do something doesn't happen to you, let's say, and you, I'm sorry, you have a will that has guardianship language in there. Remember, those guardians are not put into place until that time where you pass away. So if you were incapacitated, again, that will would not help. That's why we make sure we use it also as a standalone separate document for you. Okay. And then for our singles, you may not have children as a consideration, but what if something happened to you if you were disabled? What if you lived with a partner? Who would get your assets? Another thing to touch on quickly for singles and young people, 18-year-olds going to college. For example, my son, he's in college. I can't believe it, but he's in college. He's playing football. And I'm in the process of completing his healthcare proxy. Because with a healthcare proxy, if something happened to him, he's 18 and he's an adult in the eyes of the law. But I know if something happened to him, either my husband or myself would want to be the ones to make decisions and assist with that. So there's so many considerations with planning, and you really have to talk them through and think about what they all are. Okay, so just really quickly, I gave you a lot of information. Um, you know, just touch the surface. Everyone's situation is going to be a little different. And what we do is we answer your question in calls. We give notices and seminars. We do a review every 3 years. We give you that pat trust I talked about to protect yourself, your children's, your beneficiaries, assets in the long run from creditors, divorces, lawsuits, all of that. It's so important to select an attorney that will do that. It's really, really critical. And we also provide a successor trustee manual. I'm going to talk about that a little bit because with our successor trustee manual, a lot of times people, maybe I would venture to say over 95% of the time, a trustee is selected, an agent is selected, someone is selected to take over someone's affairs and they have no clue. And so I've had trustees call me in the past and say, I'm a trustee and I just found out I have no clue what to do. We also provide a trustee manual. So it kind of helps with, getting those trustees in place and getting them ready to take on that role as trustee. And so I want to make an offer to you, because again, this is very overarching information. Just really want to get you thinking about estate planning. But everyone's situation is specific, it's unique. And I want to provide you with an offer for a discount on future planning, but most importantly, on our strategy consultation, because I will be able to sit down and assess your personal needs. And our strategy consultation is usually 450, but it's 150. But at the end of that, we would have discussed your situation, family dynamics, again, a huge part of planning, specific concerns about your child, your spouse, maybe your parents, and you'll leave with a plan moving forward. You will leave with options moving forward. And so the value is 450, which we've heavily discounted to 150, but I want to make sure that even if you say, oh my goodness, I don't even know where to start, you will leave that session with a way to move forward in planning. And it's baby steps. You can't do it all at once, all the time. So our session will make sure that you're on the right road. So that's really important. And if you book within 24 hours, you also get, as if you pay the 450 for a session, you'll get a 450 discount on any estate plan of your choice. And like I said, strategy consultation, and then you'll get like a roadmap for beginners, estate planning 101. It will kind of reiterate what I said today and give you more, information. Okay. So the link, I think, will be dropped in the chat. I don't know if it has been dropped in the chat yet. Hopefully it has. But it will be dropped in the chat and then we can see if there are any questions at this point. I'm seeing if there are any questions. Uh-oh. Let's see here. Let's see if we have any questions. Let's see, any questions? Let's go to the chat. Okay. Okay, so yes, it is important to It is important to make sure that you know the differences between a will and a trust. But yes, a trust does avoid probate. Someone asked if it does, a trust is guaranteed to it. There's no guarantees in anything, but a trust will avoid probate once you transfer those assets into the trust. Once you transfer those assets into the trust, you will avoid probate of any assets that are living in the trust. So think of a big red wagon. If the wagon is empty, and nothing is in it, then no, those assets will not. Anything outside of that wagon will not be part of your trust, and they will have to go through probate. Okay. Is the healthcare proxy part of estate planning? It absolutely is. It absolutely is. And it's a crucial and essential part of estate planning. So when I look at overall estate planning, I'll tell you what's included. A trust, a will together. I don't just give you a trust. Once you get a trust, you have a trust, a will, healthcare proxy, and living will. And you also have healthcare directives, any funeral arrangements that you have, guardianship is done, a power of attorney is included. So those documents, those ancillary documents are a huge part of planning. And I don't give estate plan without a healthcare proxy, regardless of what you want. That's what I'm giving, a healthcare proxy and power of attorney in conjunction with everything else. It's really important. I do offer virtual sessions. Great question. It does not have to be live. Most of my sessions, in fact, are Zoom. Most of my questions, in fact, are Zoom. So most of my consults are Zoom to get started. There are people that want to come in, that's fine, because I have clients in Long Island, where I'm located, New York, but I have clients that are elsewhere. So I usually start with a Zoom session, and the only time someone would have to come in person is when it's time to sign. That day is a big day, so you have to come in person. And let me just confirm, the 150 consultation is usually 450, and that is for the consultation and will tell you a strategy in moving forward. So you can move forward separately, and we will engage after that. But 150 is a consultation. And for that consultation, I can consult with, I won't give, always give legal advice as far as just if you want a consultation to know the best way to move forward, but I can let you know, because again, it depends on your state, right? So we can do a consultation and I can tell you, overarchingly, based on your dynamics, based on what you have, based on, whatever your circumstances are personally, how to move forward. So at least you will have an information on how to move forward, and you walk away with an inventory, because that's what we'll do on that consult. We're going to do live, work. And so you will walk away with something in hand, which will be your inventory. And that's what I start most of my estate plans with, an inventory. So that's what that 150 covers. But you will get 450 credit towards any estate plan of choice. And also another great question, it is also always preferable to have both spouses together during this consultation for planning purposes, for discussion purposes, like I said, for dynamic purposes. It's always good when you're married to have your spouse present. So that's a fantastic point. And, you can think of things together, things maybe you didn't think of before, different considerations. But in that strategy session, I call it is a consultation, but I do call it more of a strategy session, because yes, you're going to leave with information, but you're going to leave with a plan and something in hand. Let's see. Do you have to find an attorney with your state to get a trust? So another great question. Someone asked, do you have to find an attorney within your state to get a trust? So just to be clear, if you, for example, live in North Carolina and you want to do a trust, yes, you would have to work with an attorney who practices law in North Carolina. Now, why is that? Because the nuances may be different in your state. There may be something that may vary in North Carolina than it does here in New York. So that's why when I give this presentation, I say it's an overarching information, because generally the information is the same. A trust is the same in every state. A will is the same in every state. How it's probated may be different, right? What the laws are around selecting an executor may be different. So yes, it is always recommended to get an attorney within your state to get a trust. However, I can also give you proper questions in my consult. Again, we will just give you like overarching ways to move forward in your state without servicing or providing a trust for you. So for example, if you say, I live here in North Carolina, what questions should I ask? What should I be looking for? How do I move forward? What are the best steps? These are my dynamics. This way you can kind of have something to compare it to for when you do actively source your attorney to provide your trust. So at that point, I would be putting on just my consult and coaching hat to assist you with getting the right attorney and asking the right questions and being educated before you get there, because it is all about education. You want to be educated and you want the attorney to know that you're educated and you know what to ask. Anything else? Let's see. And, at the end of the day, I just want you to, oh, I think I may have another question. Hold on. Okay, I think she got that. Okay. At the end of the day, I want you to think of this. We all have insurance for our car. We have insurance for our homes. We have insurance for our business, hopefully. That's another segment, but we have some form of protection around us when we're moving about in life. So I would think about estate planning as a form of protection as you move about in life. How am I going to protect myself and my family from X, Y, or Z as I move around life? And don't try to do everything all at once. Sometimes it starts with baby steps. So it's okay if there are baby steps to be made or taken. This was your first step, like I said, so kudos to you. But think about estate planning as another layer of insurance for your life, for your children, for your loved ones, and for your business. Um, and if you have questions for me, please, you can contact me. I lost my slide with my contact information, but I will just put my information here in the chat so you can have it. Um, you will have my information, my personal email, so you can kind of get to me if you have a one-off question. But I would really strongly encourage you to book and see what the best strategy is for you and your family. I may not be able to create the plan for you depending on your state, but I definitely can lead you in the right direction. I definitely can do that. That's the email address. Again, Kate, if you're still on, can you please put in the booking link again for anyone who may have missed it so they can go ahead and get their booking scheduled. Even if I can't do your trust, I definitely can help you get you on the right path and at least help you get an inventory in place, which is where everything starts and everything ends. Okay, thank you so much, Kate. There's the link again. Again, thank you so much for being here. Any personal questions? Everything is very state specific, but it's more so personally aligned with what your needs are. That's really what estate planning is. Thank you, thank you. I hope everyone books so you can take advantage of all the freebies, all the discounts, all the knowledge, and really just get yourself on a plan and a strategy for moving forward. And I respect your time. I hope you have a beautiful rest of the day, and we will see you at the next webinar. And FYI, our webinars will be changing up a little bit. So we have some other exciting topics for you guys just to keep you educated and interested in coming. So thank you again for being here. Have a great day.